All right, here's the breakdown of the preliminary hearing tape that I posted previously. It's titled Effective Cross-Examination and Preliminary Hearing. I previously told you guys what a preliminary hearing is, told you why to do it. Now I'm going to tell you how to do it. So in the case that you see posted, my client was charged with fleeing and evading, first degree, and he was also charged with possession of a firearm by a convicted felon. Simple facts of the case were the defendant is alleged to have been driving a vehicle. It was in a local apartment complex. There was a call that the person was driving around being suspicious, so the police came to investigate. They located the vehicle that they thought matched the description, followed the vehicle, turned on their blue lights. The individual got out of the car, ran off, left the vehicle. The vehicle, I think, was still running. They searched the vehicle, was considered abandoned, and found in it a shotgun, some shotgun shells, which were partially covered up in the back seat of the car. So that kind of sets the stage. My client was later supposedly identified as the perpetrator after a couple days of investigation through family members and through Facebook posts. So that sets the stage for him being charged with possession of a firearm by a convicted felon, and then fleeing and evading in the first degree. So the first thing you want to do when you do a preliminary hearing is, what is my guy charged with? And what are the elements of the offense? So possession of a firearm by a convicted felon, pretty simple. Is the person a convicted felon? Is it a firearm? And are they in possession of it? Okay. So possession is defined in Kentucky as to have actual possession or to otherwise exercise dominion and control over an object. So that would be a jury instruction, and we can kind of get into later what that really means. The second charge my client was charged with was fleeing and evading in the first degree. So to be fleeing and evading in the first degree, you have to be operating a motor vehicle. You have to intend to elude police officers. And by eluding, you have to cause a serious risk of substantial physical injury and or death. Good example would be when you see high-speed chases on the highway, guys going 150 miles an hour, weaving in and out of traffic. That is your classic example of fleeing and evading in the first degree. Now you also have, which my client was also charged with, fleeing and evading in the second degree. That would be if, there's two ways to do that. Number one, if you're on foot and you're causing a serious risk of substantial physical injury and or death, you can do that by foot. Now that would be, if you're running and you're running in and out of the highway and you're dodging cars and the police are chasing you, that can, I think that's going to rise to the level of possible serious physical injury and or death. Now, if you're in a vehicle, you don't have to necessarily cause serious physical injury or death for fleeing and evading in the second degree. You can just be driving. Like, say if you have a slow, and I've had this before, a slow speed chase where somebody's going the speed limit, I'm just not stopping. That would be a pretty good example of fleeing and evading in the second degree. So those are the elements of the offense, and that was what my client was charged with. Now, as to the firearm, the questions that I had asked the officer was, okay, where was the gun? Okay, it was in the back seat. Did he have possession of it? Well, it was covered. Okay, was it his car? No, it wasn't his car. And then made the connection to the car belonging to his mom, and then speaking with family members, the gun belonging to his mom. So then the issue is, being a driver in the vehicle, if he is assumed to be the driver, is he in possession of it? Now that's an issue for a jury, but I certainly think there's some reasonable doubt there to believe that he's in possession of it, especially since it's covered up. I mean, does he even know that it's there? So that was what I attempted to tack the Commonwealth on in regards to the possession. Now, the fleeing and evading, the real thing was the creation of substantial risk or physical danger. The police officer testified that that was caused, but on cross-examination said, well, that was caused before you put the blue lights on. And in order to be fleeing and evading, there has to be a lawful order for that person to stop. And if you're driving a vehicle, it's going to be the cops activating their blue lights. If somebody's driving like a jerk and you don't have your blue lights on, that's not fleeing and evading. That's just driving like a jerk, and that could be something else entirely. It could be careless driving, which is what they charge my client with. Could be wanton endangerment, depending on the facts and circumstances. So I was able to narrow down to the judge at least that, hey, look, the fleeing and evading, there wasn't serious risk of physical injury or death, because that would have occurred before the blue lights. So then the other issue is, well, running. Well, when I asked the cop, okay, what's the running? So, well, we thought he might have a gun. Well, first of all, that's not a risk. And just because you think somebody might have a gun, that doesn't mean it's a risk. Now, if they said, well, he had a gun and he was pointing it at us, okay, I get that. But that wasn't the case here. So that's why I asked the question, well, okay, I'm sitting here, I'm walking down the street with a gun. Am I causing a risk of serious physical injury or death to you? Well, no, the cop says no. So I think clearly the issue is they're not going to be able to get that element on the walking or the running away. So then it comes to, okay, well, did he flee and evade? Was it a low-speed chase? Ask the cop, how far did he go? Well, 100, maybe 150 feet. Well, that's not very far. This is a guy who drove the vehicle, blue lights came on, and essentially, and I think the cop even admitted almost immediately, dumped the vehicle and took off running. So it's pretty clear that the fleeing and evading is not going to stand. This case is set for trial. I'm pretty confident that the fleeing and evading is going to have to go away. Now, they may get him on the misdemeanor, because you are not allowed to run away from police on foot. But, when you're facing 20 years in prison, a misdemeanor is, pretty easy to swallow. So that was the point of that preliminary hearing. I also did use it to help help my client get out on bond. After the court heard the testimony, the judge even said, hey, look, it probably is fleeing and evading second. I'm going to let the grand jury make the decision. But he did lower my client's bond significantly, which allowed him to remain out. He's been out for 8 or 9 months. This case is set for trial at the end of March, so I'll be able to update you guys on. So that was why you have a preliminary hearing, how do you effectively use it, how to get your point across, and really to get the police under oath. So when this case is tried in March, they try to say, well, he was driving fast, and he was driving for miles. Obviously that can't be the case, because I have a videotape of the police officer testifying under oath that he went between 100 and 150 feet, immediately ditched the car, and wasn't going at high speed, and that any danger that was caused was before he turned on his blue lights. So I hope that helps you guys kind of understand the reasons I asked the questions and why I asked them, kind of where I was going for it. So hopefully in the next series we'll address arraignments. It's going to be a little bit easier, but there are some things that you can effectively do at arraignments to kind of help your case. So until the next video.